On August 1st, 2025, USCIS updated its policy manual when it came to family-based petitions. In this video, I'll be breaking down what those changes are and how it can affect pending cases and future cases. Family-based petitions are not just petitions for spouses, it also includes children, parents, siblings, right? So it's any family-based petition that you are filing falls under this category, and these changes in the policy manual can affect your case depending on your particular situation. I will be breaking down all of those changes in this video. I am U.S. immigration attorney Lilian Chukwurah, and I help my clients get green cards and citizenships for themselves and their families using the U.S. immigration law system. The first thing I want to talk about in the new press release is the guidance, right? They're saying this guidance streamlines existing policy to provide clear and consistent guidance for officers. This guidance also provides clarification on certain eligibility and adjudication requirements, including when USCIS requires an interview for family-based immigration visa petitions, and that USCIS may issue an NTA, notice to appear, to enhance benefit integrity and identify vetting and fraud concerns. This update also provides guidance related to family-based immigrant visa petitions, approvals, and denials. And then over here, this is effective immediately. It is really important to note this part because sometimes we don't think about, that these things go into effect immediately. This is effective immediately and applies to requests pending and filed on or after the publication date. So it's not just if you file your application after this, then this is what applies. Even if your case is pending, this will still apply to you. So really important that we know that and pay attention to that because it can make a huge difference for you. So if you have a case pending, or if you're going to be filing an I-130 in the future, these changes are going to apply to you, not just future cases, but pending cases as well. All right, so let's see what are these highlights. Let's look at the policy highlights. It says it incorporates existing guidance on general eligibility criteria and filing and documentation requirements for family-based immigrant petitions. It explains how USCIS adjudicates family-based visa petitions that are filed with related petitions or multiple petitions. Again, we'll be breaking these down and looking at the actual policy manual as well. But I want to start with the press release because the press release tells us what they want us to think that these things are, and then we're gonna go over it and see if it matches the press release. All right. So next, explain circumstances in which USCIS authorizes the U.S. State Department, right, the Department of State, to accept a Form I-130. Remember, I-130s are usually filed with USCIS. They're saying there's going to be circumstances where the Department of State, meaning embassies, consulates, will be able to actually accept an I-130 petition for immediate relatives of U.S. citizens. Okay, very limited criteria we're going to be looking at. And then it incorporates existing guidance explaining when USCIS will route cases to Department of State, National Visa Center, and when they will keep that application, okay? And then explains when USCIS requires interviews for family-based immigrant visa petitions. This is a big one, okay? This is a big one because typically an I-130 that is not filed with an adjustment of status application, I-485, does not typically get an interview in the U.S., but now they're saying we're going to tell you when we're going to require an interview, but we're not going to limit it to just what we're telling you here. So, and then over here it explains that USCIS may issue an NTA, notice to appear, if the alien beneficiary is otherwise removable since A family-based immigrant visa petition accords no immigration status or relief from removal. Huge. Huge. So this is basically saying USCIS will issue an NTA even if they approve the I-130, as long as the person is otherwise removable, right? If the person is otherwise removable, then USCIS can go ahead and issue that notice to appear, put them in deportation proceedings. Again, even if the I-130 is approved. So we'll talk about what that would mean for people moving forward. All right, so we are going to start with one of the big changes, Chapter 3, filing. So this is where they tell us that the Department of State can accept I-130s and adjudicate I-130s. Not just accept it, they're not just taking the I-130 and then sending it over to USCIS. They are basically accepting the I-130 and adjudicating the I-130, meaning they're also making a decision on the I-130. Okay, so USCIS is basically given this authority to the Department of State. This is typically something that's done by USCIS, right? USCIS has jurisdiction over I-130s. They're saying in these limited circumstances, they're going to give that authority to the Department of State, and that means embassies and consulates. All right, so these are the exceptions, right? Exceptional circumstances. First one, military emergencies. Again, the military gets very, members of the military, when it comes to adjudication of cases, do get, you know, more benefits than anyone else. So, which makes sense. They are in the military. They are risking their lives for the country. So it would make sense that members of the military will get special services, okay? So no one out there come for that. So they would be able to process these applications in these limited circumstances. Next one is medical emergencies. So if the petitioner or the beneficiary is facing an urgent medical emergency that requires immediate travel, this is key, right? So before, it would be, you know, when we talk about expediting a case or what's exceptional circumstances, it's typically medical emergencies for the petitioner, but this is also saying, or the alien beneficiary. So the beneficiary that's outside of the US could be facing urgent medical emergency that requires immediate travel, and for that reason, they can get their case filed with the Department of State instead of USCIS. If there's threats to personal safety, so again, the petitioner or the beneficiary, okay, the petitioner or the beneficiary facing an imminent threat to personal safety, and they give an example. You know, we love examples. We love examples because we can then, from that example, figure out what else we can try to argue would fit within that. So the example is a petitioner and beneficiary may have been forced to flee their country of residence due to civil strife or natural disaster and are in precarious circumstances in a different country outside of the United States. So in those situations, they would be able to file that with the Department of State and not have to file it with USCIS. If the beneficiary is close to aging out, so basically aging out refers to when a child is close to turning 21. So let's say a child is the immediate relative of a US citizen, but they're very close to turning 21 and aging out and basically now becoming the adult child of a US citizen. They may be able to file with the Department of State instead of USCIS. The petitioner has recently naturalized, so if they traveled for their visa interview, but the petitioner has naturalized and the beneficiary requires a new petition based on the petitioner's citizenship. Listen, this is a big one, okay? This is a big one, and this could have come in handy a while ago. They could have told us this. You know, this would have come in handy for a couple of clients. This part is important because what typically happens is if a permanent resident files for their spouse and includes their children as part of that application and doesn't file separate petitions for those children, and then they later on get their naturalization and become citizens, now those children are considered immediate relative of a U.S. citizen. Their spouse is considered an immediate relative of a U.S. citizen and is not able to then include those children. This is saying that instead of filing the I-130 with USCIS, those beneficiaries, the children under that application, can file their I-130 with the Department of State and have the Department of State process that application instead of the petitioner filing a new application with USCIS. This I like, okay? This I like. So, and then next one, adoption of a child. A U.S. citizen petitioner has adopted a child abroad and has an imminent need to depart the country. So let's say you adopt a child, you really have to leave the country. This type of case, this is really the important part that I want anyone that does an adoption to keep in mind. The I-130 requires you to have legal and joint residence with that child for at least 2 years. So this does not take away that requirement, okay? So if you have met the 2-year requirement of legal custody and joint residence, and you have an imminent need to leave the country, then you can file the I-130. So it's not just adopt a child and then have an imminent need and file an I-130. You still have to meet that 2-year requirement. Okay. Next one is short notice of position relocation. This is for U.S. citizen petitioners living and working abroad, and they have received, a job offer in the U.S. or reassignment to the U.S. So again, important because this stuff happens, and then families end up being separated because people have to leave. Okay, listen. Now, this is what I like to see. Okay, I like when USCIS gives us, their criterias and what they believe, but then when they say that the list provided above is not exhaustive, that's a good thing. That means you can argue with the Department of State and tell them, hey, this case fits within the general understanding, right? The general principles of these circumstances, right? You can't do that unless you have that language. So the Department of State still has discretion to accept a clearly approvable local I-130 petition. Okay? Unless there's, a reason that they shouldn't, they can. All right? So that is a major change that I wanted to cover when it comes to what I-130s the Department of State can accept. The next section of changes is in Chapter 5, the adjudication of family-based petitions. This is key because it tells the officers how to process these applications. So the other one says how to file, where you can file the applications. This is telling the officers how to process these applications, which applications to approve, what the criteria are for approval. As you can see here, and you will see this throughout the practice manual, there are sections that are reserved. Reserved just means that USCIS is not going to tell us what's in that section. It is for USCIS use only. They don't want to give away all their secrets, so they're going to reserve that section. That's what that means. I wish it wasn't reserved, but this is reserved. So we will not be able to see what in Section A, but a USCIS officer, when they see their policy manual, will have a Section A fully completed for them. But the public-facing manual is not going to have that Section A, okay? But let's go ahead to the next section, which is interviews. Which family-based visa applications are going to get an interview is very important to know, because when you file a standalone I-130, meaning you file an I-130 and you do not include a green card application, an I-485 with that application. You may now have an interview if you fit into one of these, okay? Typically, you weren't going to get an interview, but now they're giving us criteria of people that are going to get an interview, and we're going to go over those criteria. But let's talk about why someone will file an I-130 without filing a green card application. The first and most popular reason is because the beneficiary is not in the U.S. Okay, if the beneficiary is not in the U.S., an I-130 will be filed and then sent to the National Visa Center once it's approved for the visa to be processed. Okay. Another circumstance is if the beneficiary does not qualify for a green card in the moment. So, for example, if it's a preference category, so it's not an immediate relative of a U.S. citizen, and a visa number is not out yet, so their category is not current, then they would file an I-130, wait for their visa number to be current, and then file their green card application if they qualify to file in the U.S. Another reason that someone would not file a green card application is if they are in immigration court proceedings. So an I-130 filed while someone is in immigration court proceedings can be approved, but the person may not be able to file a green card application if they are not considered an arriving alien. So USCIS only has jurisdiction for green card applications for arriving aliens if the person is in immigration court, okay? But if you're not an arriving alien and you're in immigration court, you need to file that green card application with the immigration court if you otherwise qualify for a green card. And then there's just people that don't qualify for a green card for one reason or another, and need to, they came in without inspection, they overstayed a visa, but they're in a preference category, not an immediate relative. They would need a waiver, leave the U.S., and then come back with a visa. In those situations, again, I-130s only. So let's see who's going to be getting an interview. So the first is if there's evidence missing or the record indicates that the marriage is not bona fide. So if they believe from what you filed and what they can see on their end that this marriage is not real, they can schedule an interview. And then the next one, there are any material inconsistencies. Again, these are all about if the marriage is real, if the relationship is real, if there's anything in those applications that make them question whether there's any fraud or misrepresentation going on, you're going to get an interview. Again, this is for standalone I-130s, which usually do not get an interview. Next one, petitions for a spouse where either spouse or both spouses were under the age of 16 at the time of the marriage celebration. They want to talk to you and make sure that it was not a forced marriage or, anything that would be against public policy. Next one, petitions for a spouse where one spouse was 16 or 17 of age and the other spouse was at least 10 years older than the younger spouse at the time of the marriage celebration. Again, we want to make sure that it's legal and not against public policy. All right, they want to avoid, forced marriages and things like that. Petitions that lack reliable documentary evidence to demonstrate the existence of the qualifying relationship after, right? If they still have questions about the relationship after the officer has already issued a request for evidence, issued a notice of intent to deny, and they still have questions, they can go ahead and schedule that interview. Next, the petitions where testimony is needed to resolve any discrepancies in the record or to address concerns regarding the reliability or credibility of evidence following an RFE or a NOID. Again, if they already sent you a request for evidence or a notice of intent to deny and there's still discrepancies and things that just don't sit well with the officer, they can schedule you for an interview. Petitions for a spouse where the petitioner previously filed for a spousal petition for a different beneficiary. So basically, spouse A, that's the U.S. citizen, is filing for spouse B. But spouse A already filed for a different spouse before that. They want to talk to you and just make sure that you're not just getting married and giving people green cards. All right. Petitions for a spouse where either the petitioner or beneficiary was party to a prior denied, revoked, terminated, or withdrawn spousal petition. So if there was a petition filed for you in the past by a spouse and that petition was denied, revoked, or withdrawn, they want to talk to you. Again, just to make sure everything is on the up and up. Okay. Petitions for a spouse where the lawful permanent resident acquired their residency status through marriage less than 5 years prior to filing for the current beneficiary. Again, they are trying to basically try and find as much fraud and weed out the fraud in these situations, because they're like, okay, if you got your green card through marriage and then less than 5 years later you're filing for someone else, they have questions. Okay. Again, this is specific to an LPR, lawful permanent resident petitioner. This is not saying a U.S. citizen petitioner. This is if the person is still a permanent resident, they haven't filed for citizenship, and they are filing for a new spouse. Okay, those things have to be there. Petitions for a spouse where the marriage occurred while the beneficiary was in removal proceedings. Again, they may go ahead and schedule you for an interview, and I have had this happen. So this is not new. This is not new, right? If the person is in immigration proceedings, they may schedule you for an interview. This is saying that they will schedule you for an interview. Before it was a may schedule you for an interview. So, and then finally, petitions for a spouse that are adjudicated where, following an initial interview, it is determined that the bona fide marriage are in question. So these follow-up interviews can be are Stokes interviews. Basically, they're going to grill both spouses during that interview. Now, if you have multiple of these going on in your case, you are most definitely getting an interview. So for example, if you had a prior application that was denied and you're also married your spouse while you're in removal proceedings, you are most likely getting an interview. So the more of these you have going on, the more likely you are to have an interview, and you need to be prepared for that. Again, there's going to be other circumstances where you may be referred for an interview that do not fit these criteria, but just know these are what they're going off of, and they may expand this depending on your particular case. So I want to highlight this footnote because we just talked about all the criteria where they will schedule an interview, but I want to highlight this footnote because it just says what I just said, that they may still require an interview even if it's a circumstance that's not in that list. But they also say, additionally, USCIS conducts an interview in all I-130 petitions filed concurrently with the Form I-485. This, they hit that in the footnotes, y'all. They put that in the footnotes. So they're saying if you file an I-130 with an I-485, you are getting an interview, right? They are conducting an interview in all of those cases where an I-130 and an I-485 is filed together. So basically, this is telling me that interview waivers for marriage-based petitions, for family-based petitions are over, right? We knew that they were going to interview more of them, but now they're basically saying, oh, all of you are getting interviews. All of you are getting interviews. So this is major, and I wanted to highlight that because they hit it in the footnotes, and the footnotes matter, okay? When you're looking at the policy manual, it's great to read what they say in the actual body of it, but the footnotes It's like reading a court case for me. Like I can read a court case, the filings and all of that. But if you skip the footnotes, you are skipping some juicy detail and details that will make a difference in the way you think about the situation or the case. So definitely be reading the footnotes, because I do. Okay, so here let's quickly cover when denials are required, right? I always want to cover this because people get confused, and I just want to give you some encouragement, right? So USCIS may only deny a family-based petition if the petitioner fails to establish status as a U.S. citizen, U.S. national, or lawful permanent resident, or the petitioner fails to establish a qualifying relationship to the alien beneficiary. So if you can't show that you meet the requirements to be a petitioner and you can't show the relationship with the beneficiary, your application is going to be denied. But this is the part that I want to cover, right? USCIS may deny without first issuing a request for evidence or a notice of intent to deny if there is no legal basis for approval and no additional information could establish a legal basis for approval. Okay? This is important because they're basically telling us that if your case is denied without you being issued a request for evidence or a notice of intent to deny, it's because it wasn't going to be approved anyway, because there's no legal basis for approving your case. However, this also tells me that if there is a legal basis for approving your case, right, if they got enough information, they could approve the case, then they have to issue you either a request for evidence or a notice of intent to deny. Okay, this is very important to clarify this, and seeing it in the policy manual is also important because they put out this whole thing about not having to issue requests for evidence or notice of intent to deny for I-130s anymore. But this clarifies the situations in which that would be the case. So really important here. All right, so basically an example they're given is if a grandparent is trying to file for their grandchild, that's not allowed under the INA. So therefore, the application is not approvable. There's no legal basis to approve an I-130 petition filed by an uncle for their niece, right? So those are going to be automatically denied without a request for evidence or without a notice of intent to deny. And if they do deny your case, they're going to send you a letter detailing the specific reasons for the denial, okay? This one is a big one. This is going to be the last section that we cover because it's a big section. So let's talk about it. If USCIS determines the alien beneficiary is removable and amenable to removal from the United States, USCIS may issue a notice to appear, placing the beneficiary in removal proceedings. Petitioners and alien beneficiaries should be aware that a family-based petition accords no immigration status, nor does it bar removal. Listen, this last part is true, and I tell people this all the time. Just because you have an I-130 pending does not mean you are safe, okay? Even if you have an I-130 approved, but no green card application, no visa petition going on, you are not safe from removal, and this is what they're saying here. So for example, if someone enters without inspection and they file an I-130, knowing fully well that they would need to file a I-601A waiver later on after the I-130 is approved, this is basically saying that USCIS, even though they know the person is most likely going to file that I-601A waiver, is still going to try and put the person in removal proceedings and go through that route instead of letting them go through the route of filing the I-601A waiver. That's who this is going to affect the most. Okay, people that know they need a waiver, but they need an I-130 to be approved before they can file that waiver, this is going to be who this affects the most, okay? So if that I-130 is approved and you're not immediately filing your 601A waiver and you're put in removal proceedings, this becomes a major issue for you, because here's the thing. You cannot file an I-601A waiver while you have an open removal proceedings case. And they know this. So that is why we try so hard to manage expectations for clients, especially now they're saying it like boldly in the policy manual. This is something we kind of knew on the back end as immigration attorneys that could happen, but now they're saying, oh, we're making this very clear to our officers that if the person is removable and amiable to removal, put them in removal proceedings, okay? So be very careful when you're filing your I-130. One thing that they're also not saying here is if you, probably in a different section, but if you file a green card application and that green card application is denied and you're removable, the same thing would happen, right? The officer can issue you a notice to appear. Now, the key term here is may. May is not the same thing as must or shall, okay? They may issue you a notice to appear. Does not mean that 100% of the time, everyone that, you know, is removable is going to be NTA'd, but it does make a difference to know that this is in the policy manual and this is what USCIS officers are working off of. I hope you found this video helpful and it helped you understand better what these policy changes are and how it can affect pending and future I-130 applications. If you're in a situation where you have an I-130 pending, or you are in the process of filing an I-130 for a family member and you want guidance on the best way to do that, please go ahead and schedule a strategy session with me. It is a free 15-minute session where we talk about your immigration situation, your family member's immigration situation, and determine the best process for you to go through. If you want to schedule a strategy session, please go to my website, lilylegal.com, click on contact us, and go ahead and pick a date and time that works best for you for us to chat about your case. Also, please let me know in the comments if you have any questions, if there is anything that surprised you about the changes to the new policy manual, and if you like this style of video where I do an explainer of these policy changes and actually show you what those policy documents say. So if you like this style of video, please let me know in the comments as well. Thank you so much, and I'll see you next time. Be safe out there.